Welcome to this channel once again. My name is Akinwale. I will be speaking today on the Digital Operational Resilience Act DORA, which has been passed into law in the European Union, and all organizations in the member states are expected to start preparing to comply effective as at 17 January 2025. It is a very interesting regulation. I've gone through the regulation. I've even written a certification exam on the regulation and passed. I see it as a a basket of compliance. Honestly, that's how I see it. I can see ISO 27001 there, Information Security Management System. I can see ISO 22301 there, Business Continuity Management System. I can see ISO 27035 there. That is on incident management. Okay, I can see a lot. You have testing. Okay, so you have vulnerability assessment, penetration testing, and so many um, regulations, so many standards, so many frameworks. Risk management is there, ISO 31000, ISO 27005. It is so interesting. All right, so for people who have been in the field of information security, cyber security. All right, this is a very important regulation, which they are going to find very interesting. In this video and in subsequent videos that I'm going to be sharing on DORA, I will be sharing my knowledge on the articles in the regulation, and I will also be explaining the intentions of the authors, the intention of the writers of this law. Okay, with you. Okay, so this is going to be a very interesting session. So it's going to be like a mini series. So after this particular video. You should expect more videos from me, and that's what I'm saying. If you have not yet subscribed to this channel, please try to do so that you can get notifications and see more videos, educational videos from this channel. All right, I'll be starting the introduction of DORA in this video. And the law, the regulation actually starts with four articles, articles 1 to 4. Articles 1 to 4 uh, were categorized as general provisions. All right. So the the regulation introduces itself to us with general provision. So we have four articles in the general provision. We'll be looking at one of those articles in this section, and that is Article 1. Article 1 is subject matter, right? So what does the law say in Article 1? All right. And so Article 1, Section 1 of DORA says, in order to achieve a high common level of digital operational resilience. All right. Look at that word, high common level. So what they're trying to achieve is a level of consistency at high level, a level of predictability, a level of maturity, all right, for all the organizations in the member states of the European Union. All right, so this regulation lays down uniform, all right, requirements concerning the security of network and information systems supporting the business processes of financial entities as follows. So make no mistake about it. All right, they are making it very clear from the Article 1 that DORA is actually a sector specific regulation. So it's not for all the sectors, it's not for all organizations in the EU. All right, it's basically sector specific, and that is for financial entities. All right, so the section one, Article 1, Section 1A. All right, so you have requirements applicable to financial entities in relation to information and communication technology risk management. Number one, very key. I mentioned it earlier. So you have ISO 31000, very relevant here. ISO 27005, very relevant. All right. So these are the international standards on risk management and the information security risk management that we're already familiar with. Okay, so the law is saying that as related to financial entities, uh, this law is specifically addressing ICT risk management. All right. So it's providing requirements for organizations on how to manage ICT risks. Okay. And then reporting of major ICT related incidents and notifying on a voluntary basis significant cyber threats to the competent authorities. So look at that. Reporting of major ICT related incidents. We'll see more of these when we get to address these issues specifically. So if you have an incident, an ICT-related incident in your organization, and is categorized as major, the regulation says you must report. Okay. Once it's major, you don't have any choice. According to DORA, all right, you must report it. All right. I look at the next word or the next phrase, notifying on a voluntary basis significant cyber threat. So you see the hierarchy of classification of incidents there. So when an incident happens in your organization and is categorized as major, you don't have a choice. You must report to the competent authorities. But when it is a significant cyber threat, so it's not at the level of major, all right, then in a situation like that, you are not, you are not, it's not compulsory, all right, for you to report to the competent authority that you had a significant cyber threat. Is on voluntary basis. So it's whether you feel you should report or not. This is very important. And then as we look at the articles, when we get to definitions, so you can see Article 3 is actually on definitions. When we get to definitions, you have to watch out for the differentiation between a major ICT related incident and a significant cyber threat. All right, so there's a difference between what is major and what is significant according to DORA. All right, so if the incident is major, you must compulsorily report to the competent authority. But if it is significant, then you may voluntarily report to the competent authorities. Please, I want you to take note of that. It's very important, both for people that are writing the lead manager or certification courses on DORA, or for the people that are going to implement, all right, DORA for their respective organizations. That definition, that differentiation is very important. Okay, so let's move on from there. Reporting of major operational or security payment-related incidents to the competent authorities by financial entities referred to in Article 2, Section 1, all right, points A to D. All right, so that is also related to incident management. Okay, so look at what they are mentioning again. Look at the classification again. Major. All right, major. So security payment related incidents that are classified as major, you as an organization in the EU must also report, right, to the competent authorities. All right, so we can actually combine, all right, the previous line with this, all right, the previous requirement with this. So both of them are related to incident management and reporting. Great. Okay, so next one, all right, digital operational resilience testing. So there are requirements that DORA has placed on organizations in the EU. Financial entities, don't forget, this is sector-specific regulation. So for financial entities in the EU, you have to perform digital operational resilience testing. So when we get to that session, we'll talk more about the specific requirements. All right, you have to do penetration testing, you have to do vulnerability assessments. All right, the law talks about when you can use internal testers and when it is compulsory for you to use external testers, the frequency, right? The frequency of testing, all that is in DORA, right? So we have digital operational resilience testing as one of the key requirements of DORA. Then you have the next one, information and intelligence sharing in relation to cyber threats and vulnerabilities. All right. So what that is saying is that you need to, like in ISO 27001, there is a requirement in Annex A called threat intelligence, right? Threat intelligence, that's what they call it. And so you as an organization, you need to sit down and, and map out where are you going to be getting your threat information from. All right, so there are many sources, right? So you have, for example, you have a WASP top 10, all right, for web vulnerabilities, very common among developers. Okay, you have Kaspersky Lab. Okay, Kaspersky Lab, some organizations are using it. You have so many sites, right, centers all over the place. So you of course, like for example in banking, of course you have all these banking national banking associations, all right. Like in Nigeria, we have these NEF, right? I think the National Electronic Fraud Forum, okay, which all the banks and other financial institutions are all involved. They are all members, and and it's basically for information sharing. All right, this one has happened in a bank, or this is how it happened. So other people can learn. Everybody can, get out their, um, their um risk management framework and systems. Okay, so that's the idea. So you need to be able to demonstrate, and the regulation says you have to let the competent authorities know your choices you have made on how you are going to be receiving these intelligence and how you are going to be sharing it. So maybe you have your member states already have an association among the financial institutions. So all this is, this is actually very easy requirement to implement. So as much as possible, the financial entity is expected to be in a loop where intelligence, all right, can actually be able to get to them on time, so that they can use those intelligence to be able to show up the resilience outlook of their financial entity. Okay, so I believe that is quite clear on information and intelligence sharing in relation to cyber threats and vulnerabilities. And then, of course, the next one, measures for design management of ICT third-party risk. Wow, this is very key. This is so key. All right, it is a key requirement in DORA. All right, we all know, sometimes the problem is not with the organization, the problem is in the value chain. All right, so the problem of the vendor automatically becomes your problems. And sometimes the problem of the vendor's vendor become the problem of the vendor, and the problem of the vendor automatically becomes that of the client at the end of the day. So this is so key. All right, this is so key for survivors of survival of sustainability of organizations. How are you going to manage your vendors. And DORA is very clear. Right? For example, your vendors are expected to have security certifications. DORA is very clear about that. So one of the things that will give you peace of mind as a client, right, in EU, that is that your the people, or the clients, I mean the vendors, the third parties, right, that are critical to your survival, they are also they have some level of compliance, right? With DORA specified. So you expect them to have, many of these certifications, outside there, 27,001, 2301, 20,000, all right, 9001. So if you have vendors that have these certifications and they're actually really maintaining it, the culture gets passed down to every member in the vendor organization. Wonderful, just wonderful for that financial entity. And this is what DORA is saying. We need to, there are minimum requirements that a vendor must meet before you can hire and maintain the relationship. So this is what this law is saying here. The next is requirements in relation to the contractual arrangements concluded between ICT third-party service providers and financial entities. So this is also re-echoing, all right? ICT third-party risk management. So contracts, all right? So if it's not written, it's not there, right? So there's nothing like verbal contracts, all right? Uh, Gentlemen agreements. In this case, we are talking about financial entities that are crucial to the sustainability of nations, all right? So we need to be able to solid written contracts to manage the relationship. Okay, the next one, rules for the establishment and conduct of the oversight framework for critical ICT third-party service providers when providing services to financial entities. So this also is still on ICT third-party risk management, all right, to ensure that the third parties, they don't become a source of vulnerability to the banking system or to the financial system generally, okay, or specifically as the case may be. The next one is rules on cooperation among competent authorities and rules on supervision and enforcement by competent authorities in relation to all matters covered by this regulation. So this is not about financial entities. So that's one of the things I find interesting about DORA when I went through it, is that there are requirements there not only for the financial entities, there are requirements even for the regulators also. All right, this is one unique uh, framework or regulation actually. If you look at most of the other standards, regulations, framework outside there. So it's for the target audience, right? For the clients, for the organization. But one unique, I know, feature I've seen in DORA is that it has requirements for the financial entities. It also have requirements for the uh, regulators that will manage the enforcement of this law. Okay, so here the regulation is saying the competent, of course, we know there are, of course, diverse competent authorities in each of the member states. So they need to be able to work together, all right? So it's not a matter of competition, it's a matter of enabling one another. It's a matter of cooperation, right? So they need to be able, if you look later when we're looking at the regulation, you will see where the regulation say, all right, even the competent authority can delegate, right? You can delegate a particular enforcement responsibilities to another competent authority. Why not? Okay, so you can collaborate, you can delegate to another competent authority. So this is just perfect. This is for the regulators. Okay, so that brings me to the what we call the five pillars of DORA. So if you've looked at any material on DORA before you saw this video, so I'm sure you will have seen these five And so what I did here was to show you where we got those 5 pillars from. So it's actually from Article 1, all right, Section 1 of DORA. All right, so those 5 pillars. So the summary of everything we had here from this Section 1, all right, through to this point, all right. They excluded, if you notice, they excluded the one for competent authorities because it's not about, it's not really for the financial entities, is a requirement for the competent authorities. So if you look at everything that is there, all right, so you can see the first one, asset risk management, the second one, asset incident management, the third one, all right, payment-related incident management. The fourth one, digital operational resilience testing. All right, the next one, information and intelligence sharing. The next one is still ICT third-party risk management. The next one, ICT third-party risk management. The next one, ICT third-party risk management. So you say, so this is where we got the 5 pillars of DORA from the Article 1, Section 1 of DORA Act. All right. This is where we got it. So we have the 5 pillars of DORA. Pillar 1, ICT risk management. Pillar 2, ICT related incident management and reporting. Pillar 3, digital operational resilience testing. Pillar 4, ICT third-party risk management. Pillar 5, information and intelligence sharing among financial entities. These are the 5 pillars. I believe you can't forget now. All right. Maybe you are writing your exams on DORA or you are implementing for an organization, you're implementing for your organization. These are the key 5 requirements of DORA. Okay. So Section 2 of Article 1, subject matter of DORA says, in relation to financial entities identified as essential or important entities pursuant to national rules, transposing Article 3 of Directive EU 2022/2555, this regulation shall be considered as a sector-specific union legal act for the purposes of Article 4 of that directive. So I mentioned it before, that DORA does not hide the fact. He has said it upfront that is specifically for financial entities. So it's not for all organizations. DORA is not for all organizations. It's not for all entities in the EU. It's specifically for the financial sector. Okay. Then Section 3 of Article 1. This regulation is without prejudice to the responsibility of member states regarding essential state functions concerning public security, defense, and national security in accordance with union law. What does that mean? What does that mean? So what is simply saying here is that this law is not, you can't say these has relieved the member states, the government of the member states, of their responsibility on public security. Remember that this regulation is specifically for financial entities. We still have so many other entities now, all right? We have oil and gas, we have construction, you have health, and so on. All right, so this law, all right, does not lower the responsibility of states, all right, when it comes to, so the public security is still the key responsibility of member states, governments, defense, national security, all right. Please, they are saying please, so this is still, these things are still your baby, basically. So DORA is not taking that responsibility, these responsibilities are from the national government of the member states. So still keep your focus on your public security, on your defense, and on your national security. This is basically what Section 3 of Article 1 is talking about. Okay, so this is Article 1 subject matter of DORA. All right, so in subsequent videos, I will be talking about the Article 2, 3, and 4. All right. So if you have questions on DORA, all right, you can comment, you can post your questions or comment in the comment sections, or you can send me a mail, all right, on this email, you give me a WhatsApp message on the phone number on the screen, and I'll be more than willing to answer your questions, your queries, all right, on DORA. Okay, so I know there are many experts aside there. Let's talk. Let's share information on this new law. So thank you so much for taking time to watch this video and listening to me. So I'll see you in the next edition on the Digital Operational Resilience Act, DORA. Thank you.